What's up, everybody? Stephen Lefkoff here, Lefkoff Law. I got an interesting question from a client the other day that I thought would be worth sharing on video, and the question was pretty simple. It was, when is the Court of Appeals going to make a ruling in my appeal case? Did you know that the Court of Appeals and the Supreme Court of Georgia have specific deadlines by which they can make their rulings? And that's governed by the Georgia Constitution, the Constitution of our state. The Georgia Constitution says that a Supreme Court of Georgia case or a Court of Appeals case must be ruled on within either the term in which the oral argument is being held or the following term. And the terms are also defined. There's a December winter term, an April term, and an August term. Those terms have specific dates. In our case, we are in the August term of 2019 for our case, and the distress date, what they call the distress date, when the case must be decided, is March 16th, which is just a few days away, which is why the client was so curious, hey, why haven't we heard yet? It's really interesting because we're going to hear soon, right? March 16th is only a few days from when this video is being filmed. So with each passing day, I know, hey, we're getting closer and closer to when we must know, which is March 16th. So if you're ever involved in an appeal case, you're considering an appeal case, you're thinking about appealing your case, or you get that question, when is the appeal going to be decided? You can check, in our case, the Court of Appeals website even has the terms listed and when the deadline date is. Now, they call that a distress date, and I'm sure there's a reason why it's called a distress date. We can all imagine the kind of distress everybody at the Court of Appeals is under as you're getting closer and closer to the deadline by which they must issue opinions in those cases. My name is Stephen Lefkoff. I am an Atlanta, Georgia general practice attorney. I am here in front of the Bridge to Nowhere in Atlanta, which if you haven't seen or heard of, it's a pretty famous landmark of a bridge that is literally just cut off at the edge. And I got that question about the Court of Appeals. I thought, what better place to talk about where something has to be cut off than the Bridge to Nowhere. So, just to recap, the Georgia Constitution states that a distress date, or the date when a decision must be made in the Court of Appeals or the Supreme Court of Georgia, is and must be by the end of the second term of your case, of the term that your case is assigned to. Now, there are a couple other details about motions for reconsideration and deadlines for that push it a little bit earlier than exactly the end of the term, but it's still right there. Stephen Lefkoff, Lefkoff Law.